At least 20 states and the District of Columbia have enacted laws authorizing the involuntary commitment of sex offenders. In 2006, Congress passed legislation allowing for the civil commitment of sex offenders in federal prison. In Kansas v. Hendricks, the United States Supreme Court considered several constitutional challenges to a Kansas law. In 1994, Kansas enacted the Sexually Violent Predator Act. The act established an involuntary civil commitment process for potential repeat sex offenders. The act defined a sexually violent predator as a person with a mental abnormality who was likely to commit future sex crimes. The act applied to any person incarcerated for a sexually violent offense who was soon to be released. Kansas first utilized the act to commit Leroy Hendricks. Hendricks had a long record of molesting children and was scheduled for release from prison soon after the act took effect. As part of his commitment proceeding, Hendricks demanded a jury trial to determine if he was a sexually violent predator as defined by the law. At trial, Hendricks testified that he couldn't control his urge to molest children and that death was the only guaranteed way to stop him. The jury unanimously found that Hendricks was a sexual predator, and the court ruled as a matter of law that pedophilia was a mental abnormality under the act. Hendricks was committed. Hendricks appealed to the Kansas Supreme Court and challenged his commitment on due process, double jeopardy, and ex post facto grounds. Hendricks argued that the act was punitive due to the potential for indefinite confinement and because it failed to offer treatment. The Kansas Supreme Court ruled that the act violated Hendricks's constitutional rights because the use of mental abnormality as a commitment standard didn't satisfy the due process requirement of mental illness. The court didn't address Hendricks' double jeopardy and ex post facto claims. The United States Supreme Court granted cert.